I really appreciate you stating what you stated. I was not prepared for my actual adverse possession case. I didn't understand what all other motions would be heard. My very first one, you signed off that there was the ex parte was declined, and then I was going to have my quiet title on the December 1st hearing. And when I got here, it was only for ex parte, so I wasn't prepared for that because I was prepared to deliver that then. I had a whole folder for it. So if the courts would please allow us to come back to another day for the actual adverse possession claim, what I would like to present to the courts today, Your Honor, is something called, now I apologize for not knowing the direct legal jargon, but it's something along the lines of the poisonous fruit doctrine.
The fruit of the poisonous tree.
Fruit of the poisonous tree doctrine, Your Honor.
Now, that is a criminal process. That is a criminal principle, which basically says that if there is an illegal search, then any evidence that is obtained as a result of an illegal search would be the fruit of the poisonous tree, and as a result, it would be excluded. Normally, that has no application in a civil case, which is what we're dealing with.
I understand that normally that would not adhere to such a case. However, I've been arrested over these matters several times and have been dealt great stress and cause by the defendant. And I do not wish her any form of, I don't know what my letters wrote. I don't want her to go to jail. I don't want her to be punished. From what I understand from Miss Wallace, she was the first lady officer here in Dover, and I respect her for that because I'm a girl dad, Your Honor. However, she lied to the sheriff on November 4th when he came over to my house. She lied again November 12th. She lied to the courts on December, somewhere about December, saying that she had rights to this property. She filed an illegal detainer warrant. She's had me locked up several times, Your Honor. And I do have all the proof on my phone. I requested that I use my phone to be able to present any form of evidence. I also have 3 copies, one for Your Honor, one for Miss Wallace, and one for myself, which is a new motion for Exhibit XX bundle that proves everything that I'm saying today is very true.
Well, I want to make clear to you, I want to give you an opportunity to present your case, but this case arises from your claim of adverse possession and ownership by adverse possession under a state statute. And that is the issue that is controlling all of the motions that you have filed. All stem or arise from or are connected to your claim of ownership. Your complaints that you're giving today are not a part of that action. They're not a part of what we are supposed to be hearing today. Today is supposed to be solely about whether or not you can establish a legitimate and sustainable claim of adverse possession and ownership of this particular piece of property. So I'm willing to let you put on your proof on that issue. But that issue is what everything else is arising from. You have a number of motions. For example, you have all these motions for a stay of immediate stay of eviction, opposition, to a motion for an order. That there are just so many motions. Your motion for relief, your first amended complaint, a motion for relief, your supplemental filing, and a motion for relief, your objections. You filed a letter to the clerk. Your amended and supplemental motion for relief, an emergency motion for immediate ruling. And what I'm here today to do is, because of the numerous motions that have been filed, I'm trying to give you an opportunity to establish whether you have any standing to even litigate this issue as a claim for adverse possession and ownership.
This guy walked into court acting like he was smarter than the judge, and it blew up instantly. He started throwing around random legal terms, accusing people of lying, and completely dodging the one thing the judge actually asked him to prove. Meanwhile, the judge stayed ice cold while this hearing slowly turned into a total train wreck. What do you guys think? Genius strategy or absolute courtroom meltdown? Like, comment, and subscribe for more crazy courtroom drama.
Well, Your Honor, you wrote in your judge's order on December 1st that I do have an adverse possession claim. You stated that if you were to be the one to hear it.
A claim is not anything more than a claim. Somebody has a car wreck, they have a claim, but it's to be established whether they have the right to judgment. So you have a claim that you're making. A claim is nothing more than an assertion that you have a right. And the question of whether that claim is legitimate and whether that claim is one that should be granted is an issue that is for a final determination. I'm trying to give you an opportunity because all of the other motions you filed all stem from your claim for adverse possession. If you don't have a sustainable claim for adverse possession and ownership of the property, then you have no right to the property. You have no right to lease the property to your tenant, and therefore all of your other issues would pass because of that fact. So the first and foremost claim is for adverse possession. And are you prepared to litigate that issue today?
I have a folder that I've submitted to the judge. Ms. Wallace has seen it prior, I believe. She can correct me if I'm wrong, please, ma'am. I can try to go off memory from what that folder was. I'd be able to, because it's just the truth. My family's lived at 2138 Old Highway 79 since March 2000. Continuously. Grandparents, uncle, myself, all the way to this day. The neighbor, Miss Marvin Wilson, who said that she had no family. So our family took care of her. My grandparents passed away a year after moving in there. My uncle and father continued taking care of it. My father died. My uncle continued. When he died, I continued. That's where my claim comes. That's been for over 25 years. And in that folder, I've got pictures. I've got documentations.
Excuse me for interrupting.
Yes.
What folder are you referring to?
With all my exhibits, the one that I requested that if Miss Kim has seen.
Well, are you saying this is a folder that you produced and gave to Miss Wallace?
I've given it to the courts on December 1st, Your Honor.
So is that then something that's contained within the court file?
Yes, sir. It should be. It was documented.
And I have in the court file, there are a number of color-coded tabs. Is that what you're referring to?
I'm referring to the bundles that are exhibits A through F, I believe, with F being all the laws that I've tried to quote, because I wasn't familiar with them as far as December 1st goes, being able to recite them. I'm not a lawyer. I'm a normal human. I'm a normal man. I'm a Stewart County man, and I got educated here, so I try to be as prepared as possible.
I have in the court file, but it was apparently filed at the time of the last hearing, there are a number of tabs. They start with full script, exhibit list, lease, tax receipt, photos, keys, my affidavit, LRG Homes.
Yes.
Is that what you're referring to?
Yes, sir. LRG Homes LLC is the registered principal business at 2130 Old Highway 79. Further in showing my adverse possession of being open and hostile as the law is required. It's been over 25 years. I've contacted Mr. Ruben Wyatt, which I've tried to add for the audio files to be accepted. I've contacted our neighbors. I've used Ancestry.com. I've looked at Miss Wilson's obituary where it just said the family. I went above and beyond and done my due diligence, Your Honor, in order to find out if Miss Wilson even had family.
This guy really thought he was about to win the case with a giant folder and Google-level legal research, but the judge wasn't buying it that easily. He started claiming his family owned the property for over 25 years, bringing up tax receipts, photos, obituaries, ancestry records, and stacks of documents while trying to prove adverse possession. But wait until you hear this. The judge kept pressing him on one simple question: can you actually prove legal ownership or not? The longer this went on, the more it felt like a courtroom documentary turning into a full-on legal meltdown. What do you guys think? Solid evidence or just desperate scrambling? Like, comment, and subscribe for more crazy courtroom drama.
And then I went into this court system several times, Your Honor, and requested that if there are any probate against Miss Wilson. When I originally filed, they said there was none with Miss Wilson. And then whenever I did some more research, I found out there was one for Miss Marvin Wilson Rimley. So then they added that. which changed another motion that I had to add.
Okay, so that we're clear, I'm going to give you an opportunity to present your proof. You cannot submit a written statement and rely upon that. You can't just file a bundle, as you refer to it, of exhibits. You have to make, under the rule, you're representing yourself. You have to take the stand and testify, and then you can introduce an exhibit. And if it is admissible under the rules of evidence, then that exhibit would be allowed. But there are things that you need to understand. I'm required by law to hold both you and Ms. Wallace to the same standard as if you had an attorney representing you. And because of the fact that we're dealing with the ownership of some real property that has value, I'm required to do it in a way that gives you both an opportunity to be heard, but I'm not going to open it up for you to just basically make a bunch of hearsay statements about things. You're going to have to adhere to the rules of evidence for me to make a ruling if one way or the other. So
may I request from the court, since you did admit to what you should have recused yourself from the thing, may I ask that you do that and appoint a special judge?
on what basis do you have for me to recuse myself from this case?
You've already admitted to knowing Miss Wallace, and you openly stated whenever we first came in here on December 1st, you said, "I know Sheriff Gray, how you doing, Miss Wallace?" And then you pointed to me and said, "And you are?" That was very intimidating for me, sir. Your Honor, respectfully. And then when the paperwork said that the TRO had already been denied, and then I was having a hearing for my quiet title claim on December 1st, which you should have those documents, Your Honor, that it was for my actual quiet title. So I came in here with 3 folders prepared, one for Your Honor, one for the defendants, one for myself. But you said that we were only doing the ex parte TRO that day that had already been denied previously. And since that day, I had already been arrested several times. Marcus Jackson had been arrested several times. And now since December 1st, I've continued to be arrested. That's why there's so many motions there, Your Honor. I've been stonewalled by clerks. I have proof. I've been lied to by clerks. I have proof. I've been lied to by county attorneys. I have proof. And I'm prepared to present it in front of a judge that would be fair, Your Honor, respectfully, sir.
All right, well, under Rule 10 of the rules of the Supreme Court, I'm required to make a ruling on your motion to ask that you're asking for me to recuse myself. I'm required to make a ruling on that before we take any further action. So we'll take a short recess.
All rise.
This hearing went completely off the rails the second the judge explained the rules, because the defendant immediately accused him of being biased. The judge calmly told him that filing random folders and paperwork wasn't enough. He actually had to testify and follow real courtroom evidence rules. But then came the twist. The defendant demanded the judge recuse himself, claiming he felt intimidated just because the judge knew the other people in court. He started accusing clerks, attorneys, and even the entire system of lying to him while the judge sat there trying to keep the hearing under control. What do you guys think? Unfair treatment or total courtroom chaos? Like, comment, and subscribe for more crazy courtroom drama.
Rule 10 of the rules of the Tennessee Supreme Court, court is required to address any motions that's made to recuse or disqualify a judge in a case. I don't believe that I have a conflict in this case, but because of the fact that I'm familiar with Ms. Wallace and have all of the other 3 judges who preside in this court have already recused themselves because of their personal knowledge of Ms. Wallace, and I had agreed to hear this case despite the fact that I had some prior history, because I believe she would be the one who would be entitled to raise an objection to me hearing this case. But based on Mr. George's objections and the fact that he raises the issue that I'm familiar with Ms. Wallace and he doesn't think he can get a fair hearing, I've reviewed the Canon 2 of the Rule 10 of the rules of the Supreme Court. And out of an abundance of caution, I'm going to recuse myself from this case. Now, because I have recused myself from this case, all 4 judges are now out of this matter. What that means is that we're going to have to designate a special, ask for the Supreme Court to designate a special judge. There will be no action taken in this case until such time as that special judge is. So there's nothing, in my opinion, that needs to be filed. Of course, I'm recusing myself, but I'm just telling you that the clerk's office can't do anything for you until the special judge is designated. So I know you have some issues, but I will state that our clerk's office is a professional group of people. They deal with people. My experience has been politely. You may have strong emotions and feelings about the situation, but I would urge you to deal with them professionally, and that you'll get better service from that rather than creating any sort of issue. Based on my having found that I am required to disqualify myself, I will have, based on his objection, I'm continue or adjourning this hearing until such time as a special judge is designated.
Your Honor, can I ask one question?
Yes, ma'am.
He is continuing to collect rent, and I filed a motion that that be to the state because
Objection, Your Honor.
Be quiet, please. What is it?
T-Care has, has a lien on the estate, and he did not check it down. This is very frustrating and has been a nightmare for our family.
I understand
Being
that.
accused of things that are not correct. And I have hardcore documentation, wills, taxes, that some landscaping has been done and mowed by us, electric bills, water.
Mr. George does not own this property. He has a claim for ownership, and that's why, under the circumstances.
But why
Yeah.
should he continue to collect money off something that is not his? That's my only, I would just ask that you consider putting that in a trust or an estate, and so he no longer collects money.
Well, and I think that's a legitimate request, but having recused myself from the case, that'll be up to the special judge to do so. Mr. George, I would simply comment that even though I'm out of the case, I've advised you on more than one occasion, you have a claim for ownership. You don't own the property until a judge rules that you do, and therefore, under the law, it would seem that no one has, if you just have a claim for ownership, you don't have the right to lease the property or collect monies regarding. I'm going to leave that to the special judge who's going to be designated to make that determination. But it may be a situation where Ms. Wallace is correct that those monies, you may be liable for the rent that does it, but that'll be up to the special judge. I have recused myself, so this matter is.
This courtroom hearing took a wild turn when the judge decided to step away from the entire case over possible bias concerns, even saying he had no real conflict but would recuse out of caution. Wait until you hear this, that one decision removed all judges from the case, freezing everything until a special judge is assigned. But even after that, the arguments exploded over property, rent, and ownership claims, with the judge reminding everyone that a claim is not the same as legal ownership. Now the entire case is on pause, no rulings, no progress, just complete legal limbo. What do you guys think, fair process or total chaos? Like, comment, and subscribe for more crazy courtroom drama.